Joining us now, Dan Balz, Washington Post chief correspondent. James Sample is Hofstra University law professor and former attorney at the Brennan Center for Justice's Democracy Program. So, James, the White House is claiming a definitive victory here, I guess full steam ahead, that gives them sweeping powers. Is that what this says?
It doesn't actually say that. As with many of the decisions from the Supreme Court's so-called shadow docket, it says almost nothing in terms of rationale. But the impact of what it does, as opposed to what it says, because it says very little. This is a very brief, unsigned order, but the effect of this is extraordinary. The effect is that, for now, the administration can move ahead with its plans to restructure, massively restructure, the scope of the federal government, meaning that thousands, hundreds of thousands, potentially, of federal employees will soon be losing their jobs, and the administration will be able to restructure numerous administrative agencies. This was a big, big step by the administration early on in the first 100 days of the Trump administration, and the lower court said either no or at least not so fast. The Supreme Court said green light.
So green light, and even if ultimately there is a more fulsome review of the policy, and let's not kid ourselves, this is about the executive power and the balance of power that's outlined in the Constitution. A lot can be done between now and then.
A lot can absolutely be done between now and then. And if you are one of those employees, and this was one of the arguments that the challengers advanced in this case, once they've lost their job, once time has passed, and it's going to take a long time to litigate this fully, if they ever get to the point where this is declared illegal, which seems relatively unlikely with the current court, even if they were to reach that point, as the challengers put it, you can't unscramble that egg.
Does history show us, Dan, that it's very easy and can be very fast to shut down an agency or tell a bunch of employees you don't work here anymore and turn off their access cards, their key cards, than it is to rebuild an agency or get people back to work?
Yeah, I couldn't agree more with James. I think that we know that this court has a deference to executive power and has ruled in a variety of ways over a period of time to give the executive more power. We also know that this has been the strategy of the Trump administration in this second term in a way that they were not able to do in the first term, and that is to try to get a control over the executive branch that they feel would give them the powers that they have wanted to, in a sense, have their will versus the bureaucracy. And, let us say over a long period of time, this is declared as not legal, that they can't do this without congressional approval or without other restraint. At that point, it's going to be way too late. You can't unscramble the egg. You can't unring the bell. You can't unravel things that have been done. You can't put it back together. And so I think the strategy of the administration has been clear from the beginning, which is to issue their executive orders, move ahead with what they are trying to do, let it get tied up in the courts, assume that the Supreme Court is going to be more deferential to them than not, and to go ahead and move as quickly as they can and see what the consequences are.
Your colleague, Dan, at the Washington Post reports that agency employees reacted to the Supreme Court's ruling order with grief, despair, and anger, according to interviews with half a dozen staffers and chat records obtained by the Washington Post. What can you tell us about how this uncertainty continues to weigh on federal workers who have kids to put through college, food to put on the table, roof to put over their head? And one of the things about going into service, whether it's at a state level, federal level, is some level of certainty about your job.
Well, I think that from the beginning of this second term of the Trump administration, there has been a callousness and insensitivity to the human cost of what they are doing. Look, all administrations have the right and the ability to try to put forward policies that they want to do, and we've seen efforts in the past to try to reform government, reinvent government under the Clinton administration with Vice President Al Gore in charge of that effort, which resulted in significant reductions in the size of the federal government. But this administration has done it in a different way, and it has left human beings in a very, very precarious position And we've had stories from the very beginning of this administration about the consequences of that and the sort of the turmoil that individual federal workers are going through with both the uncertainty and then even the certainty that they don't have a job anymore, or that they're cut off from their email or their office or their ability to know what their rights are. So this aspect of this policy, I think, is particularly difficult for people to understand why it has to be done in this kind of cruel and callous way.
So we only have a few seconds left, James, but do federal workers have any other legal recourse here?
The individual federal workers may have some contractual rights, some union bargaining rights, but on a constitutional level, their only right now is to suffer the cruel callousness that Dan referenced.
James Sample, Dan Balls, gentlemen, thank you so much.